So it says we're recording, but I can't see anything. Hello? Hello?
Diane on Zoom.
Hi.
Hey,
Diana.
you look green.
Hi.
You
I
guys
look,
okay?
I know.
No,
I
you don't
think
look
I do.
green. I'm fine. You look fine.
No, do I look green, right?
No.
No. That was from your Zoom call yesterday.
Oh, yeah, I was green yesterday.
I got the table all to myself.
I know, you get all that room spread out.
Coming in crispy clear.
I'm hoping that the dogs will stay quiet.
No, they won't.
Diane, we're all set whenever you're ready.
Okay, let's call the policy committee meeting to order, starting at 6:30. So we have, 3 policies that are up for rescission. The first policy is 5120.8, missing school without parental consent unaccounted for. You should find in your packet the Shipman and Goodwin notes regarding the policies tonight. They suggested repealing this policy and replacing it with a model policy, which we have already adopted, which is policy 5113 and its associated regulation, which you should find in your packet as well, just for review. And so recommend rescission. Any discussion or questions about this policy?
I'll be the slow kid in the room. What was the number again?
Sure, it's 5120.8, missing school without parental consent / unaccounted for. So actually, this policy also references policy 5080 absences and 5080.1 tardiness, which we have already rescinded. And then it also mentions policy 5080.2 truancy, which we did update. And 5120.8 is already replaced with 5113 and its regulation. So there's no reason to keep this policy. So I just need, if everyone's okay with rescinding it, I just need a motion to recommend to rescind it to the board.
So moved.
Second.
Thank you. All in favor, aye.
Aye.
Okay, the next policy is 5120.9.1, supervision of students. Let me just put this aside. Hold on one second. Shipman and Goodwin recommend rescinding this policy because job descriptions and collective bargaining agreements address the duties of teachers and other staff members. And also the policy applies broadly to all schools and age levels. So this is pretty much in collective bargaining agreements. There's no reason to have this policy, so they recommend rescission. Any comments or questions regarding this policy?
No, I agree with that.
Okay, so can we recommend to move this to the board for rescission?
So moved.
Second.
Aye. All in favor? Aye, thank you. The next policy for rescission is policy 5120.9.2, student dismissal precautions. Shipman and Goodwin recommend rescinding or repealing this policy. This topic concerns day-to-day operation and is best included in the regulation or school procedures. So they recommend rescission for this as well. And if Dr. Cook, could you just comment on this?
Yes, it's exactly as you said. It's in the school procedures and how students are dismissed. So that would be a better place for it than through board policy. I agree with Shipman's recommendation. The action.
So it differs from building to building as well.
Correct. And even sometimes the buildings might change from year to year, based on something they feel is better.
Okay, so any other questions or comments, or we can recommend to move this forward to the board for rescission?
No comments? So moved.
Second.
All in favor, aye?
Aye.
Great. Okay, so those are the policies for rescission. And we're going to move those to the board. Now we have policies for review. And the first policy for review is policy 4040, plan for minority educator recruitment. If you read the Shipman and Goodwin notes, the changes in this particular policy were made due to a new law that was passed on effective July 1st of 2023. The state law requires that the plan be named Increasing Educator Diversity Plan. And therefore you will see that policy 4040, the name has been changed to Increasing Educator Diversity Plan from the previous name, Minority Recruitment Plan. And then the new law also references changes from the word minority to diverse without redefining the term's underlying meaning. And then also a note from Shipman and Goodwin is that Boards of Ed should note that pursuant to Section 10 of Public Act 23-167, we are now required to submit our Increasing Educator Diversity Plan to the Commissioner of Education by March 15th, 2024 for review and approval. And they also recommend in customizing and implementing our plans, we should be mindful of state and federal legal requirements, as well as evolving legal developments in the wake of the U.S. Supreme Court's decision in Students for Fair Admissions, Inc. versus the President and Fellows of Harvard College, and Students for Fair Admissions, Inc. versus University of North Carolina. So most of the changes you'll notice are just the changes that they said about the new name change and the new wording change. So there's really not a lot to this policy with regards to the change in the policy wording. So I was going to recommend that we waive the second read on this when we forward it to the board for review and replace. Any questions or comments?
I agree.
That's fine with me, yeah.
Okay, so we just have a motion for that.
So moved.
Second.
All in favor, aye.
Aye.
Okay. So we will waive the second read. We'll recommend that we waive the second read for that, since it's just minor wording changes. And the next policy is 5110.4. Student discipline. This policy was last revised January 4th of 2022. And Shipman and Goodwin have revised the policy again to add the definition of protected class harassment and clarify that the protected class harassment is an offense that may lead to disciplinary action. And further, pursuant to changes in Connecticut law regarding the legalization of cannabis, under certain circumstances, they clarified about the sale and distribution of less than a kilo of cannabis is not subject to mandatory expulsion pursuant to the Connecticut General Statute Section 10-233D. And so they have made additional technical revisions for clarity as well. And so my only comment about this policy 5110.4 student discipline would be on line 571. And this is just like one of the technical revisions that they were doing throughout the piece. It says superintendent or designee, and they've been replacing throughout the entire document the superintendent or the superintendent's designee. And so just to be consistent throughout the document, starting at 571 is where I saw it, but it's also in other places through the document. So if we could just replace that phrase, the superintendent or designee, to the superintendent or the superintendent's designee, then it would be consistent with the rest of the changes that they made. Does anyone have any other comments or discussion?
No, that's a good catch. Thank you.
Is there anything else that anyone wanted to talk about this particular policy? Most of the changes are just, they added the term impartial board and the designee. So if there's no other questions or comments, can we have a motion to forward this with the changes that we discussed, or to recommend repeal and replace to the board? Thank you.
Second.
All in favor? Aye.
Aye.
Thank you. Okay. Next. Hang on, I lost my place. Sorry. Okay, so policy 9540.2, construction and posting of agenda.
You skipped one, Diane.
Oh, did I? Oh, I'm sorry. Where am I?
Admission to school before age 5.
Oh, thanks. Okay. Oh, so this is the new policy, brand new. So I would recommend that we do 2 reads on this. And the only change that I saw with this would be line 20, the superintendent or the superintendent's designee in replace of what it says. And then I would have, if no one else has any other comments about the wording, I just have a question for Dr. Cook about, because this is a new policy and we know it's a new law. And for anyone who could possibly be listening, that's not us. This is regarding admission to the public schools at or before age 5. It's a new law passed by Connecticut that effective July 1, 2024. All the children who are, you must turn 5 by September 1st of that school year in order to attend kindergarten. So that's what this new policy addresses. And my question is, do we have a regulation for this yet? Because starting at line 20, it says the superintendent or the superintendent's designee shall be responsible for developing administrative regulations in furtherance of this policy. And the regulations shall identify procedures for the receipt and processing of requests for early admission to the district and for assessing whether early admission of a child is developmentally appropriate. So I was just wondering where we were in that process of getting the regulation and what kind of assessments and that sort of thing.
Sure. So when this was passed, the State Department of Ed is supposed to deliver guidance to school districts. They delivered some preliminary guidance more about communication, but they haven't delivered the formal guidance to us yet. As you know, about 2 weeks ago, we did release some information to our community, and we've been publishing that as much as we can. I received a number of calls over the summer. I haven't received calls recently on this, but I know our families are watching because they've planned and had individual conversations with a number of them to let them know about our waiver process. So our hopes is still that families that had planned and fall within those 4-month timeframes would be able to enroll, but they would go through a process just as described in law that would be at the school building. They would go and bring their child, and their child would speak with our, work with our staff and go through a evaluation to determine if they're ready. And I think in most cases we'd be looking at that they would be ready. In those cases where it's a December baby or November, we work with the family, but let them know the concerns that might be there if they enroll at that point.
Do we have
Most of our enrollments that fall within those 4 months are within September, October. Our families have been from, in a lot of ways already following this, except for some of those September and October babies.
so it shouldn't be too much of a
We're hoping
burden
it's going to an impact because the alternative for us is we only accept the kindergarten class that's 8 months of enrollment, and then in 2025 we're looking at a kindergarten class of 16 months of births. So that would be problematic for us, I think. In terms of staffing, in terms of the reorg, a lot of reasons that I think it's best. And the other reason too is if we hold students out, we're taking up a preschool spot potentially for a 3-year-old. And so that's problematic because already it's difficult to find preschool opportunities in town.
Thank you. So does anyone else have any comments or questions regarding 5040 admission to the public schools at or before age 5?
No.
All right, so I just need a motion then to send it forward to the board for approval.
So moved.
Second.
All in favor?
Aye.
Aye.
All right, great. Okay. Now we come to policy 9540.2, construction and posting of agenda. And I'll just bring to your attention that this is a 9000 series bylaw, and therefore, in order to pass it, will require a 2/3 vote at the board level. So Shipman and Goodwin made some changes. This is says pursuant to the Freedom of Information Act, we're required to post an agenda in various locations at least 24 hours prior to the meeting. Although we have always done it, Section 6 of Public Act 23-160 now expands the duties of boards of ed to require us to post on the board's website any associated documents that board members may review at such meeting, provided that they are not exempt from disclosure under FOIA. And so the model policy has been revised to reflect these new requirements. Do we have any discussion or questions regarding 9540.2 construction and posting of agenda, formerly agenda? If not, then I would ask for a motion to send this forward for rescind and I just completely lost my words. Replace, rescind and replace. Thank you.
So moved.
Thank
Second.
you. All in favor?
Aye.
Aye. All right, thank you. Okay, and now we're to policy 5180.1, confidentiality and access to educational records. You'll notice that there's a list of policies under it because they will all fall into this new revised policy. So you will find the new revised policy 5180.1, confidentiality and access to education records, which will replace our current policy of 5180.1, records confidentiality, as well as policy 5180.1.1, directory information, and 5180.1.2, relations with non-custodial parents, and 5125.1, health medical records. And then in addition, because it also covers it, is the rescission of policy 5100.9.1, student recruitment. Because it is referenced in this policy, but that policy is also covered by policy 2280, which we adopted on April 6th, 2021. So I had a couple of comments about a few places in this policy. If no one else has anything to say, I will go first. So the first one is under letter J. So this part is bolded by Shipman and Goodwin, and it says whether or not we wanted to keep this in the policy. So I would defer to Dr. Cook on this. So it's line 109 to 116.
We do not.
So we can remove those, the entire letter J.
Right.
Great, thank you. And then also under Roman numeral 6 on line 3, oops, sorry, above Roman numeral 6, line 335. This area is bolded by Shipman and Goodwin, and it's regarding charging a fee for copies of education records. Because the prior paragraph discusses how the school district cannot charge a fee, that there's one free copy for students that have special education and related services. And then lines 319 and 320 talk about charging for additional copies, but it must be in line with if we charge copies in general for other students, which is lines 335 to 342. So I would just like Dr. Cook to comment on that.
We do not typically charge, the 50 cents a page. We are able to, under FOI, for records requests as well, and do maintain our right to do that. That's in a different policy. I just want to make that statement. But for student records, we have to charge the 50 cents.
So would you recommend keeping this in this policy or removing it?
The only reason why I would see you potentially wanting to keep it in there is if for some reason there was repeated requests for records, where it became problematic, then we could, but so often we're electronically sharing records with families, you know, when we can. So and it's not in current policy, but I don't feel a need to have that in there.
You said it is listed somewhere else.
Not in any policy that I'm aware of.
So then you would recommend removing from line 318 to 320, there's that note from Shipman and Goodwin, and then lines 335 to 343, removing all that so that we don't have
Correct.
anything in there.
Yes.
Okay. All right, so we'll remove all that. I just didn't know. I figured that we probably didn't really do it, but I didn't know if you wanted to keep it in
Yeah,
just so we reserve the right. But if you don't want that in, that's fine.
I think it's fine without it.
Does any of the committee members have any questions or comments about that?
I appreciate that. I don't feel we should charge unless it is a problem, as you had discussed.
And then the other question that I had was line 755. Shipman and Goodwin have in bold there was to insert the name and contact information regarding questions and concerns relative to breach of security, who it should be referred to.
You know, I think I immediately think of Art Sickle, but I almost think it should be myself, and then I would refer to the appropriate person.
So would you like it to say to the superintendent?
Yes, I think that's probably the in our organization, I think that makes the most sense.
Would you like it to say the superintendent or the superintendent's designee? Or would you like it just the superintendent?
I just the superintendent, and I
Okay.
would designate it at the
Okay.
time.
And that was the only questions that I had regarding that policy. It is a lengthy policy, but as I said, it's replacing 5180.1, 5180.1.1, 5180.1.2, 5125.1, and 5100.9.1. Any questions or comments from the committee? So then I would need a motion to repeal and replace 5180.1, 5180.1.1, 5180.1.2, 5125.1, and to repeal 5100.9.1.
So moved.
Thank you.
Second.
All in favor?
Aye.
Aye, thank you. Okay. Moving on. We can't come to policy 9450 committees. You'll find in your packet the current policy of 9450 board committees, which we would repeal and replace, and 9450.1 committee of the whole, 9460 advisory committees. And we would repeal and replace those with 9450 committees. And then we would also need to rescind 9740 board community relations. So in looking at the new revised 9450 committees, you'll notice that there was inserted the word advisory. So it reads special/advisory committees. And then, so my question for the committee is regarding, we have the new descriptions of our 5 standing committees and the duties of the standing committees. And if you look at our our current policy of 9450 board committees, in the second paragraph, it talks about standing committee membership. And the current policy reads, the board chairperson shall designate standing committee members subject to board action. Therefore, any member of the board who is interested in serving on a particular standing committee shall notify the chairperson. And then if you look under duties of standing committees, it says standing committees are assigned regular duties as described below. The board chairperson may assign additional tasks or responsibilities to a standing committee as needed. That's pretty much it. So my comment on this is that it never actually says in the new policy that the committees are assigned by the chair. Unless I missed it, but I read it through a couple of times and I'm like, it doesn't actually say that. So if you want to just take a minute and look at the policy. It talks about each particular standing committee and, what their duties are, which is fine. And that's all a new description. But it just says that, the standing committee chairperson and members shall serve for the same term as the board. It never actually says how the committee members are assigned. And so I didn't know if we wanted to revise it to include some sort of statement. Thoughts? Because the old policy clearly says the board chairperson shall designate standing committee members subject to board action. But the new one doesn't say that.
I would think we should keep it with the board chair to assign, because I feel like it has to be somebody. It has the final say on it.
That's pretty standard.
Yeah.
Yeah, good catch.
I think it might have just been an oversight that it was left out. So maybe we could just sort of sneak that in there somewhere.
Do you have a preference as to where?
No, I don't. It doesn't matter where. I think I would just like to keep that the board chairperson shall designate standing committee members subject to board action. I think it's nice to include the line that any member of the board who's interested in serving on a particular standing committee can notify the chairperson, but I don't know how the committee feels about keeping that in. It's kind of like people do that anyway, so.
I think that's reasonable, because it's saying anybody has a shot to be on any committee they'd like, they just have to speak up.
Galen?
I agree.
Okay, so we'll just keep both of those statements in somewhere in the policy, don't care where. Did anybody have any other thoughts or opinions on the new revised 9450 committees, or about rescinding the 9450.1, 9460, or the 9740 board community relations?
Yeah, I think. No, we support it. Thank you.
Okay, let me just get my 60. All right, so then I need a motion to repeal and replace 9450 board committees, 9450.1 committee of the whole, 9460 advisory committees, and rescind 9740 board community relations.
So moved.
Thank you. Second,
Second.
thank you. All in favor? Aye. Thank you.
That's-
I think you guys need some coffee tonight or something. Geez.
Good. Well,
All right. And so the next policy should be a fun one. So it's currently 9710 school district logo and or motto, and 9720 guidelines for use of district logo / board member names. And so the last time we talked, we went through a whole bunch of changes that we talked about, and also changing where it is, moving it from the 9000 series. And we decided to make it, Zoe and I decided to make it a nice even 1200 to move it into the community school relations. So the new revised policy would be policy number 1200, school district logo. And you have the new policy in front of you. And then the associated regulation, regulation 1200, school district logo. So my questions for the committee to discuss would be, number one, should under the regulation, if you read, well, first of all, line 7 should be addressed past tense instead of address. But besides that, it says if the requested modification pertains to the athletic logo and or mascot, the AD shall chair the committee. And I would like to add, and be a non-voting member of the committee. I feel like the chair should chair it and not vote. And then I also would like the board chair and superintendent to be ex officio non-voting members of that committee, and also include one Board of Ed member. And also, should this committee, it says it would be a informal committee. Should it be a special or advisory committee, or should it be an informal committee? So coffee talk, let's discuss.
I would think that the chair and the superintendent should have a vote on the committee. They're going to be invested in all of the meetings.
Well, typically on all these committees that the chair sits on and the superintendent sits on, they are typically ex officio
Oh, I see what you're
non-voting
saying.
members. So they're
Oh, right.
there to, hear everything and give input, but they don't vote. But whatever happens on this committee anyway, it will come back to the board for the board's vote. It's non-binding. But I just would like them on it because I think that their opinions are important to be on it. That's just my opinion of it. And I think that it's important that the AD, if it's involved in if it's the athletic logo, that the AD should be the chair of that committee, but he should be non-voting. So thoughts?
Well, I agree with your position, Diane, so.
With D not being a voting member, you feel that?
I think the AD should not be a voting member.
What do you think, Dr.
I-
Cook?
I'm just trying to. I just want to make sure we're on the same page with everything for this. So we say modifications that would not fundamentally alter the character of the existing logo and or mascot shall be addressed by an informal committee of relevant stakeholders.
So I'll tell you what I was trying to do, and I'm not
Yeah.
sure if it's worded exactly to say what I was trying to get across. So,
Right.
so I wanted to make it difficult to change the logo outright, like, to change us from a tiger to, a seagull. That it would be very difficult to do that. You couldn't do it just on a whim. And that's why it would be it would be under the policy 1200 school district logo. But if you wanted to change like we're doing now, like, oh, we want to keep the paw, we're keeping the tiger, but they're different iterations
Yes.
of what we have, then I still think it's important to have community input, but just not at the same level as as if you were changing everything. And so I wasn't sure like how to do that, because I don't want to leave it up to just the AD, because we wouldn't be where we are now because we did that already, so like we did that once already. And so that's why I want further oversight, but I don't want to make it difficult because I want the AD to be able to be like, hey, it's October, breast cancer awareness. We want to make it pink and not have it black and gold. And that is not a big deal. And I don't want that to require a committee. So I'm
Okay.
not sure how to make that worded.
Because I could see somebody reading this and saying that would need a committee, or tennis rackets or field hockey sticks would need a committee if they were like on the paw.
Right. And that's not what I want. That's not what I was
Okay,
trying to
right.
get across, but I couldn't.
Yes.
So it needs more wordsmithing, but I'm not really sure.
Okay.
And why were you thinking that the AD would be the chair and not a non-voting member? I would kind of think it'd be up to the committee to pick their chair, wouldn't it?
Well, because if it's about the athletic logo, I think that's like directly under athletic director,
But it's not just the athletic logo, it's the logo that we use for the whole town, right?
Well, I mean, yes and no. I think everyone identifies with our athletic logo as being Madison Public Schools, but it's not actually Madison Public Schools logo, it's the athletic logo. So there's like a distinction, but it's like splitting hairs.
What are your thoughts on that? That strikes me as unusual.
I
That we
would
designate the chairperson and it would absolutely be the
I think because it's an athletic logo, it would be the AD, and I would be okay with him or her not voting. I think that because I think what this would be a call to coaches and teams or students and just like get the committee together, you know, and then have a couple meetings, move forward, you know, come up with a plan, whether it's, you know, maybe it's to have a student design something or to do something like that and then take action. But like, I don't think it would be a drawn out, I would hope it wouldn't be a drawn out committee. I think what we maybe should do through the reg is separate the two. You know, talk about the district logo and then the athletic logo in separate paragraphs. So I think we could, I can work, you know, I can come up with something and share it with you before our next meeting.
Okay, because it's just like right now where we stand with our current mascot, we know we need to change the tiger and
Yeah.
also the paw, but not change it fundamentally, just, you know, an iteration of it. And so that particular change, I feel is more significant than like, I would like to add tennis rackets. You know what I mean? Like the change of tennis rackets and pink for October breast cancer awareness or stuff like that, I feel is like that's the AD's business.
Right.
But I just don't know how to word that.
I
But the
think-
actual, but do you understand what I'm saying? Like the actual picking of the new tiger or the new paw, I think should be in this committee. And I don't know, should it be considered an informal committee? Should it be considered a special or advisory committee? I'm not sure.
I understand what you're saying.
I think the first line is good at the start. Modifications that would not fundamentally alter the character of the existing logo and or mascot.
Or
May be utilized by specific teams or something like that. You know, I think that's what that's a line we can work with. Because that's what I would say. That's not fundamentally altering the character of the existing logo.
Right.
Why do you think the paw? I think the current paw works. I think the tiger needs to be replaced. That might be for the committee, obviously.
Well, I mean, if you look into, I looked at a lot of different paw logos, and I have also done some research about universities that use the paw logo and some of the legal wranglings that they've gotten into because of paw logos that look similar. If you look at our paw logo, it is clearly Clemson's paw logo. And what we did was in some iterations that the scar that looks like a little D in the lower right-hand corner is removed. But the rest of it is exactly the same. And that is such a very specific paw. It literally came from a tiger for Clemson. So it was made specifically for them. And there are lots of teams that use paw logos. And if you look at a lot of our booster clubs and stuff, you'll see a very generic paw. And that is something that is like not registered. It's not trademarked. It's not, lots of people use like a plain, not shaggy edged paw, but just like a rounded, if you know what I'm talking about. And I think that would be a fine, you know, iteration of the paw, but the very specific shaggy edged paw logo that we use, I am not fine with using because it is clearly everybody has pretty much said, hey, you know, you're using Clemson's logo. And so I think the further we get away from that, the better.
I think we could hire an artist and it wouldn't even be that expensive to make our own paw logo. And if we like the hairy paw print, that could be part of our direction, like to go somewhere, you know, like we want it to be this generic, but we want it to be whatever we like about different logos, like that's reasonable art direction, and that's not that art directors and artists know how to work with, that isn't ripping off somebody's paw, because we don't have to stay away from a fuzzy paw just because Clemson has it, but to be at the same exact angle, to have the scar, to have, you know, the hair like peeking in the exact same spots, like that's an issue, but we could still have, I think it's adorable, the paw with the fur on it, and we can have that.
I mean, and
We have a
that's
different
fine.
name,
Oh, good.
right, because Clemson's tilted,
Yeah.
ours is
that's fine.
straight.
So, yeah, but I've actually seen, you know, legal lawsuits that involved logos that were just tilted and it was considered the same. Because, you know, depending on if they're using it on the helmet or they're using it on the jersey or they're using it on something else, it tilts, it changes color. And so something as minor as tilting it is not really enough to make it different. I mean, you could of course hire a lawyer to decide that, but it's just my opinion that the farther we get from looking like it's the same thing, just tilted slightly to the right or the left, would be better. So,
Yeah, I
but-
agree with that, because it's the furry paw, and it's the same exact, you know, peaks and valleys in the hair.
exactly,
But if
exactly.
we have an artist make us our own logo, it'd be fine if it was on the diagonal.
Right, and
like,
that would be
you
up
know?
to the committee to decide, right? I mean, that's what the committee will be for, is to say, okay, this is the paw that we want to use, or a call to artists to make a paw, and the same with the tiger, so that we're not using like, you know, Missouri's tiger or Towson's tiger or any other
I think we
university's
have our
tiger.
own paw print, and it might cost us a little money, but it's not gonna cost a lot.
I mean, honestly, we probably have enough artists in our own community to come up with something that would be fabulous, you know, or even using like, I mean, if you look at Daniel Hand High School's tiger logo, I think that's a great tiger, but maybe, I don't know if that's, you know, difficult to put on helmets or jerseys or whatever, but, you know, I think that however the committee decides to go with either, you know, calling for a unique, you know, artists from the community or finding one or whatever, that's not what I'm trying to say here. I'm just saying that what we have needs to be changed, and that this policy needs to ascertain the difference between selecting something like that versus, you know, the tennis rackets added to the tiger or whatever.
I'm thinking we don't need to be like very specific in the policy. We can give the direction to the superintendent, or we give it to the AD, that we need our own paw and we need our own tiger, and what the concerns are. Do you feel like that'd be enough, Diane?
No, I don't trust to put it under one person's direction, because we already did that and now we're here. So that's why I like the fact that the regulation says that, well, that we're proposing says that there will be, you know, a committee, even if it's an informal committee or a special or advisory committee. And that's one of the things I didn't know, like, do we keep it as an informal committee and without defining what that is, or do we make it a special or advisory committee so that it already has a definition? And that's something that I'm not really sure. So I'm kind of looking for Dr. Cook to jump in.
I mean, I agree with Maureen, but I think we're at the point where the high school is going to run a committee, like, you know, and I think that that's good. I never like writing policy to something that happened previous, you know. I think it's, you know, you always learn from items, but I think if we start writing policy based on a decision an employee made years ago, I think that can be problematic. I would just point that out, but I think if we could take some time with the policy, the high school committee, I spoke to the AD today, and he assures me that that's going to start soon. And they're looking at both of those logos that they use, and I think they could come back and maybe almost be something we want to, you know, hold on the policy till we see what their work is going to be.
Well,
But I think typically most districts, I think our size would just say, like Maureen said, like it would just be like, okay, you know, superintendent received direction, we're going to run a committee and then go forward, because it could be problematic. So what I get worried about would be a board member might interpret this as that we couldn't use fencing, swords, or tennis, you know, rackets or something like that on a logo for like a team. You know, like if a team decided to do something like that, like on a alternate like shirt that they're buying, or you know, we just had the alumni buy a throwback uniform for the football team. Now that could happen years from now. They want to use one of the former logos, you know, so I could see an AD or superintendent being called a question on that policy that was written, that that's not the intent of the policy.
Well, I think the intent of the policy is to make sure that, one, it's not easy to change district logos or athletic logos at the drop of a
Right.
hat just because somebody doesn't like it, but also to protect, you know, going in the future, that if it does need to be changed, like Guilford had to change their Indian, that it has a process in place so that it's not just one person's opinion, that we have a process to include the relevant community members, the stakeholders in the process. And hopefully we'll never have to do it, but if we do, we will have a policy in place.
No, I
So
do
this-
agree. You know, we do not want to be changing logos or just, you know, quickly grabbing something and using it, because you're buying uniforms, so you're putting on uniforms that last 3 or 4 years. So even when we make this change, we'll still have uniforms in play. We'll still have people wearing, you know, warm-ups and things like that that have the old logos on it. So I do agree that that's the case. Unfortunately, we're Tigers. We shouldn't have any objection to that going forward. But yeah, so
So I think this just needs some more wordsmithing and,
yes,
and,
yeah,
you know, if any of the committee members can come up with some magic wording of this, that, you know, email it to me. And maybe Dr. Cook, you can think on this for a little bit, and
yes.
you know, Zoe and I can work on it with you and come up with another iteration that is a little bit, I guess, more delineating. Does that
I
work
do
for
agree
everybody?
with you, Diana, because I have seen the tiger change and the paw print change tremendously, even within 1 year. And we don't want that, and we certainly don't want to copy a trademarked logo of any sort. But I also think that we don't want to be too tight in the policy, that there isn't flexibility or there's misunderstandings.
Right, it's just, I just couldn't find a good way to say it, like, I knew
Yeah.
what I was thinking, and I told Zoe, we kind of mulled it over, and it's just not exactly right yet.
I mean, the fact that we're even having this conversation, and it's clear that, you know, some board members aren't happy that we're using, you know, a logo we shouldn't probably have picked up. That's enough to, you know, I think bring some attention to it and make sure that we get it right this time.
And honestly, you know, it's gonna be like, we're kind of gonna look, no matter what we adopt for like the next 6 years, it's probably gonna look like a mishmash out there between all the, you know, athletic teams, because it's a slow turnover of uniforms and you're not gonna get everything. I mean, even some of the folding chairs have a tiger design on the seat. So, you know, it's gonna be a mishmash, and, you know, that's just how it is. But I just would like to have something in place so that, you know, we're protected and we have a way to go forward. So I guess we'll move on from that. And the last item, we'll table that for now and bring it back. And so the last policy on the agenda is 5030.2 inter-district school attendance areas. And we actually haven't made any changes to it yet. I put it on the agenda so that we remember that we still have to do it. It got tabled from before, and we're currently waiting for some guidance from Shipman and Goodwin before we go forward on that. But it's just sort of a reminder that we have to do that. And I don't want to forget about it and have it get lost. And so that's all I have for tonight. So does anyone have any comments or questions? Do we have anyone online that has a comment or question, Zoe?
No,
Committee
one online.
members? Okay, thanks, so. Does anybody have anything to discuss, or did we actually end early?
Yeah.
We went through like 20 policies.
Yeah, very,
Alright.
very efficient tonight with, repealing and replacing multiple policies for one, 4 for 1 and 3 for 1 and
Yeah.
10, so that's good. It, what it really is doing, and you know this, the committee knows this, is making the policies more accessible to families. So, and when you, right now, or before, when you clicked on the 4000 series and you had all these different policies drop down, it was very difficult, I think, for our families and even our staff to kind of maneuver. So this makes it much easier to access. I think it's important work.
I also like that now on the website, when you go on it and you look at a policy, the regulation is right there. So you can click on the regulation and that comes up, and that's, usually a much more verbose document. So, but it's,
Yes.
handily accessible. The forms are there, the regulation is there. And I just think it's a lot easier to navigate. And I thank Zoe for all her very hard work on this.
You're
So
welcome.
I just need a motion to adjourn at 7:20.
So moved.
Second.
All in favor, aye.
Aye.
Thank you. I'll see you guys later.
Thanks,
Thank
Diane.
you, bye, Diane.
Bye.